Good afternoon, everybody, and welcome. Thank you for joining our monthly tax investigations webinar. My name is Dave Jennings. I'm an ex-HM Revenue and Customs Inspector of Taxes with many years' experience investigating various individuals, businesses, high net worths, and the like. I've spent the last 14 years with various accountants and specialists helping clients with HMRC problems, disclosures, investigations, inquiries, dealing with appeals, which is our main topic of today. I'm joined here by my colleague, Imad Ilyas, who's head of our tax investigations. Do you want to introduce yourself briefly, Imad?
Oh, yes. I was just waiting for you to finish. Good afternoon, everyone. Thank you for joining us. Just a bit of background on myself. Me and Dave, we cover very much same area. So I've been involved in fraud investigation, Code of Practice 8, Code of Practice 9, disclosures, alternative dispute resolution, tribunal, virtually almost everything that I can think of in terms of that falls under the umbrella of investigations, and been doing it for a long time. And we've got the webinar today, which where we'll cover tribunal appeals, reviews, and ADRs. So over to you, Dave.
Yes, thank you again, Imad. As a firm, obviously, we have wider full tax and accounting services, but our specialist subject is anything to do with HMRC, any disputes, investigations, inquiries you may have. So I will start the slide presentation, and today's topic is what happens if you disagree with HMRC. So what are your options? What do you do? So you've had maybe an inquiry, an investigation with the revenue, you've been unable to reach a resolution, you've been unable to reach an agreement. The revenue have either issued closure notice or formal assessments, penalty notices, or a review decision letter. At that stage, your options are either give up, accept what the revenue say, pay the money, and walk away, case closed. But for many people, that's not a realistic proposition. Usually, there's going to be a dispute. The area might be contentious. There's going to be a disagreement around the amount or the years that have been involved. So your options are to obviously make an appeal against that review, assessment, decision, closure notice, whatever the formal notice that the revenue issued. You can appeal that. You can request and review by HMRC, and that's the first point we will cover in a minute, or we can ask for mediation, which is the alternative dispute resolution. My colleague Imad will touch on that for you, or you can go straight to the tax tribunal, and I will cover that point. So the first option is the review. It used to be known as an internal review. It's and dealt with by the review team at HMRC. It's always somebody who's not the caseworker, not the officer dealing with the actual investigation, not the person who's been dealing with the inquiry, who issued the assessments or the review decision letter. It is somebody independent from that. They are now all dealt with by the solicitor's office within HMRC, and they deal with all these reviews. So it's now known as a statutory review. So for direct tax decisions, you must have either had a notice, an assessment, or a view of the matter, which is the inspectors, officers, caseworkers' conclusions of their inquiry, their view of the decision, what they think the tax liability is, and the reasons for that, together with any penalty that may also be charged and in point. You can therefore ask for a view of that matter, and they will send that to you, and you then request a statutory review. For VAT, it may be a formal decision or a notice of assessment. and you can ask again for a review, but you can also take the case straight to tribunal or to alternative dispute resolution. So as I mentioned, these cases are centralised by and managed by HMRC Solicitor's Office. They deal with tribunal cases as well. So they are experienced in litigation. They are HMRC officers, caseworkers, but they are not connected to the original case. So it's an opportunity for somebody else to put a fresh pair of eyes on it. And I think in general, people are have had maybe a bad view of reviews, and certainly many cases where I've asked for an internal review, the reviewer quite often rubber stamps what the caseworker has said. You have to bear in mind that all they're seeing is the conclusion that the inspector, the officer, has made. They're not re-reviewing all the papers. They're not going through the full case. They're not going back on the documents and evidence. They're reviewing the position as per the conclusion and that notice or assessment. However, the stats actually show up that in many cases, in fact, the majority of cases, decided in the taxpayer's favour. So you might think, well, this is a fantastic opportunity. Let's do these reviews and win. Those stats are slightly skewed in that I think around about 80% of those reviews relate to VAT penalties and surcharges. And quite often in maybe VAT penalty surcharge cases, the revenue had been a bit quick on the uptake to each of those penalties and notices without full grounds and considerations of the behaviours or what has actually happened. And I think in those cases, they are not possible to be substantiated by the reviewer. So I think if it's a VAT penalty or surcharge case, then definitely ask for a statutory review if you've been unable to get rid of the penalty. We can help you with these statutory reviews. We can put in further arguments and defence against the penalty notices and surcharges, and we have lots of success with these sort of cases. If, however, it's on a complex direct case, direct tax issue, corporation tax, income tax, then it's maybe unlikely the reviewer will overturn the caseworker's decision. And you might think, well, what is the point of this? I mean, one of the points is that if the case proceeds to tribunal, quite often the judge at tribunal will say, was there an internal review? Was there a statutory review by somebody else of this decision? And they may then ask, why didn't you request a statutory review? So you've got to be ready, obviously, with a reason and an answer and decision. It's not obligatory. You don't have to have a statutory review. The tribunal don't always expect it. But obviously, the tribunal want either party, especially the appellant, the appeal, the taxpayer, they want them to try and pursue every other angle possible to avoid a case coming to tribunal. Tribunal is costly, it's expensive. It takes time to have cases reviewed. The tribunal would rather a case be resolved outside the tribunal if possible. It's not always possible. So therefore they do expect people to maybe have requested a statutory review. It doesn't preclude or stop you from taking other actions, and it may not be the appropriate course in your particular appeal or dispute with HMRC. It is something to consider and is something that can be applied for. But as I mentioned, the tribunal do ask for people to have considered alternative routes for trying to settle appeals in cases. And this is where the ADR comes in. And I'll hand this over to my colleague, Imad. Thank you.
Dave, just moving on to before moving on to ADRs, a point on the reviews, it has to be a very balanced decision. Because certainly you and I have discussed this point before as well, and I've seen with our experience that mostly the thing, when you put something in review, majority of the time, what we've seen is they just simply reaffirm the decision on the main aspect. If anything gets changed, normally it would be the penalties. in which case equally you want to consider when you're going up to tribunal stage and you did take a review and the decision has been reaffirmed, that sort of puts some points in favor of HMRC and it strengthens their position. So now, one of the things that obviously the tribunal and the judge will always see, did you try and resolve this through other means? So one of them you've just spoken about is review. The other one, which we deal with extensively, is alternative dispute resolution. Now, ADR, put it simply, it's an attempt to reach a resolution. So what happens is you put the case into ADR. ADR is basically a facilitated meeting. So you've got a mediator who works for HMRC, but they are completely different. They're completely separate from the caseworker. They have no connection with them. And the concept is they will arrange a meeting. Now, to explain it, I'm talking pre-COVID. What will happen is you'll agree a venue and we will be on one side, the taxpayer, and HMRC on the other side, and the mediator is sort of in the middle, and he's trying to facilitate a resolution. Now, the idea behind alternative dispute resolution is you put everything on the table on the day to try and reach a resolution. Some other points on that is, when can you apply? Now, on the if you look at the actual guidance, they will say that you can apply at any time during investigation and up until a tribunal hearing date has been set. But what normally happens in practice is, once you have gone through the whole route and there is an HMRC have reached a decision, you will then appeal that decision and appeal that decision with HMRC. You will then decide whether you want to accept a review or not. If you've gone for the review, then you must wait for the review to be concluded. And once you've crossed that stage, there's an appeal to the tribunal, and then you go and apply for ADR. Dave, sorry, just add the point about COVID. Obviously, with the current environment, the ADR meetings that we are having, it's the same concept. It's just being done via Teams. So it's all arranged by the ADR team. They will normally go through the routine, just making sure everyone's comfortable with using the technology, and we'll all gather on a Teams meeting instead of being there in person. But it's the same concept and it works quite well.
Yes, thank you, Matt. I think even pre-COVID, there was some less complex, more straightforward cases might have been by way of telephone mediation as well. Obviously now people have got used to video mediation, and that's the way it's currently happening. And I think that's going to be the case for the next number of months. I don't know when the revenue will go back to having face-to-face ADR mediation meetings. I don't know. You brought up the point that ADR can be applied for requested at any point. I think the issue there is you can't apply for it too soon, because it'll just be rejected. If there's nothing to really mediate, if it's still fact finding, if you've not exhausted negotiating with the caseworker, then the ADR team are highly likely to reject the ADR application. So it is towards the back end.
Of course, I mean, this is what this is just coming off their guidance, but normally, like I said, in practice, we would never do that, because in practicality, it wouldn't make sense. Where is the dispute? If you have a letter from the inspector saying, send me your bank statements or send me invoices, you can't put a dispute to that. There has to be a dispute or an appealable decision, which is normally when in practice we would opt for ADR.
Yes, I mean, if you've got a very complex big case, it's possible that ADR could be used for a element of the overall investigation and inquiry as well. It doesn't have to be the full full issue, the full position for the inquiry. It could be a select point that is maybe stopping progress on the investigation. It is reasonably flexible, and it has been in place for a number of years now, and certainly we found it extremely useful, and we've had some very, very good results for clients. Imad and the team here at Churchill Tax Advisors are very, very experienced in the ADR process, and we have a number of ADRs lined up over the next few months with HMRC. So it's a very, very good tool to try and reach an agreement with HMRC. Obviously, both parties have to accept that they have to maybe budge and move. It's no good going into mediation if you're saying it's 100% I win. There's got to be an element of moving there. It is, mediation by its term is to find some way to resolve the case. It's not with a tribunal where it's one thing or another. Very rarely will a tribunal negotiate a settlement, a figure. The tribunal will decide on the facts of the case one way or the other on the balance of probabilities. ADR therefore gives a way of trying to negotiate along that scale from 0 to 100, which either party accepts. But again, there's no obligation to agree. If at the end of the ADR, the result or the option that's maybe on the table can't be acceptable by either side, then obviously you're in impasse again, and the next stage is tribunal. You're not forced to accept the decision.
I mean, in almost all of the ADRs that I've done, and this is why this process is quite good, because wherever you reach a stage where there is no movement from both sides, by default, when you put it into this process, and when HMRC come into the process, on the day of the meeting, you would normally see that everyone's come in with the mindset that yes, you will come in today to offer movement, be practical, be pragmatic, and bring some sort of movement or reach a settlement.
Yes, good, thank you. So if that doesn't work, so you've had maybe your statutory review that didn't work, didn't resolve, it didn't get a satisfactory outcome, and you've tried ADR, and again that didn't get a satisfactory outcome, or ADR isn't appropriate, or it's been refused by HMRC. Ultimately, ADR is at the behest of the revenue. If the revenue say no, we're not doing ADR in this case, you can't make them. There is a statutory rule that allows you to apply for ADR, but there's no statute that says the revenue have to give it in every case. They can turn it down if, for instance, the issue has wider connotations across the taxpaying public, or it's extremely complex litigation, which is not appropriate for mediation. It's a tax technical matter, or it's just the revenue maybe don't even have the resources. Again, is another point where they could reject the ADR. So if you've either gone through ADR, it's not resolved the matter, or you've bypassed ADR and gone to the tribunal, then what happens at the tribunal? Well, this is where obviously the clients and the taxpayer's position can be argued in front of an independent judge. These are fully full-time employed judges of the tribunal service, nothing to do with HMRC, nothing to do with accountants or solicitors or anything like that, although many of them have a background in accountancy or are lawyers to get on the bench to be tax tribunal judges. And both parties present their case. The process may be a number of hours. It can be, in the most minimal level, a paper review of the case and the files by the judge, or it could be now, obviously with COVID here, a video tribunal for a day, half a day, or in the bigger, more complex cases, it can last for weeks or even months in the very, very large contentious tribunal cases. So you can imagine, obviously, if it's a big case, it could be quite costly for professional fees for someone to be at the tribunal for a number of weeks. But the vast majority of cases that are dealt with at tribunal are usually a day maximum for a hearing, maybe a couple of days if it's quite complex. I've taken cases through tribunals with teams at offices where I've worked, and equally I've engaged tax counsel to assist as litigant in the case and present and cross-examine on the day the particular case. So again, you've got to weigh up how much tax is involved, what's in dispute, how much is it worth appointing counsel, for instance, to help represent in the tribunal. It is like a court of law. The appellant presents their case first, brings in witnesses if necessary, get cross-examined by HMRC. HMRC put across their arguments in case and witnesses. The appellant can cross-examine HMRC's witness, and then both parties sum up, with the appellant having the final sum up and conclusion at the end. The tribunal may decide on the day, but quite often they will take the case away, they will take the bundle away, they will take away all their notes from the tribunal hearing itself and reach a conclusion and decision which will be issued in writing in a few months after the hearing. In some cases I've seen it can take up to a year for the tribunal to issue a decision in the very, very complex cases. But it is an opportunity for the taxpayer to be a witness themselves or to bring in third-party witnesses to support their case. It will always be decided on the facts of that case and the history involved in the dispute. So it's crucial to get the facts together for this particular tribunal. The first tier is very much the fact-finding tribunal. The facts of a case are not usually heard at the upper tribunals. So if the appeal goes to the higher courts, it's extremely rare that new facts can be introduced. New law, new arguments can maybe be brought in at a later stage at a higher court if the appeal proceeds further, but facts are not usually able to bring up later on. So it's crucial to get all the facts together for the first tier tribunal. It's pretty much your only opportunity to present your case to the judge with all the evidence, all the documents, all the arguments, and hopefully, obviously, win that particular point. If either side is unhappy with the decision, then you can apply to appeal to the upper tribunal. That's at the behest of the first tier, and they will either grant a further appeal. If they refuse, you then have to go direct to the upper tribunal to say, please hear my appeal on these grounds. A grounds for appeal to a higher court has to be on the point of law. It has to be that the judge erred, made an error or mistake in their decision of the law, their understanding of the law was wrong, and therefore there's a dispute going further up. You can also potentially appeal if the judge has totally misinterpreted the facts of the case. That's quite rare, but again, that's another point that could be taken to the upper tribunal. Beyond that, you're then looking at the Court of Appeal and ultimately the Supreme Court, which is the top level of courts in the UK. And tax cases do sometimes progress that far. The time scale from a first tier to Supreme Court can be anything up to 4 or 5 years. You're looking at about a year for each stage of the process. With COVID, I think many of those have now gone on longer than that time scale because of the backlog of cases. Getting a case listed for the tribunal at the moment is under quite a backlog of cases. Was there anything else you wanted to add around tribunals in that?
Well, I think you've summed it up pretty well. What I would want to add is just from that, we look at it from the angle that we are always looking at it. Tribunal should really be, and this is what the judges say, it should really be the last resort. Things that you need to keep in mind. And most of the cases that we look at, you need to find, if you are someone who knows that if you can't, it's what you can live with. Are you comfortable in going into something where you know you are either going to win everything or you're going to lose on all the points? Whereas with ADR, where most of the clients are comfortable with, is in the sense that there's a more pragmatic approach to settlement, and there's a bit of give and take, and it comes to a position where you're not really taking that. You're not in a position where you know that if the decision goes against me, I lose all the points. And then the other element is costs. That's not to say that it applies in every case. So where you know that there is very solid grounds, and there is precedent in other cases, in previous tribunal cases, and quite often this is what we would do with ADRs as well, where HMRC know that our position has strong backing with other cases and similarities. Then you might, if you want, you can go to tribunal, but it's an important decision, and all the different factors should be considered.
Yes, on the point of costs, something else to bear in mind as well is if the tribunal decide the case is complex, so there are 3 levels of cases generally at the tribunal. There's the basic paper review by the tribunal. There's the standard hearing by the tribunal, or there's a complex case. So complex obviously is something that is more extensive than a standard dispute. It could either be something that's very complex in law or very complex in the matters and the size or the issues at hand. Only the complex category of cases have the ability for costs to be awarded to the winning party. So if you lose, you could end up bearing and paying the costs of the other side. So if you're the taxpayer, you could, in a complex case, end up paying the costs of HMRC for the tribunal as well. However, with complex cases, you can opt out of costs, and most people probably would. No matter, even if you're 100% sure you're going to win the case, you may still choose to opt out of costs, just in case, because you never know. And I've always said to anybody going to the tribunal, always expect the unexpected, because it's something you never expected to happen will happen in a tribunal case. Something you couldn't imagine possible would occur. It always does. And therefore, if you want the risk of costs added to all that, then fine. You stand the chance of winning your costs. If you win, you can claim against the revenue for those costs. But if you lose, you can end up paying HMRC's costs. Once a case goes up to the upper tribunal and higher, then it's always on a cost basis. So the losing party will always have to pay the winner's costs, their legal costs, counsel costs, their own in-house costs. Those costs are awarded by the judge if you can't agree the amount to pay. It's not going to be 100% of your costs. It will usually be something between 50 and 75% of your costs that you'll be able to claim, or that you may have to pay to HMRC if you lose. One thing that first-tier tribunal will not decide on is a point of administration or a point of dispute over how the revenue have dealt with the case. You can't appeal on fairness or anything like that for a tax tribunal. That is appropriate for judicial review. So if you disagree with the way the revenue have handled the case, or the way that they are using their procedures or their administration, or you think the fairness is in point, then that is for judicial review. And those cases are always dealt with by the upper tribunal and above. So that's not on a point of tax law. It's not on a point of facts and evidence. that's a point of administration. If you're disagreeing with the way the revenue have handled the case, judicial review is the appropriate form for that. So in summary, we've covered the options if you disagree and dispute how HMRC are looking to resolve the case. If they've issued a notice of assessment, closure notice, a decision letter, a penalty notice, then you can appeal that, you can ask for a review, you can request the alternative dispute resolution, or you can go to the first tier tax tribunal. And we have experience of all these different options and cases. The revenue are not always right, and tribunals do go either way. The revenue always point the statistics out that they win 80% of avoidance cases, for instance, but they don't win 80% of every single tax tribunal case. I don't think there are any. I'm not aware of any specific statistics showing what the result is of tax tribunals. It may be interesting to find out if there is any statistics on tribunals and how many of the revenue actually win. So if you've got any questions about appeals, tribunals, ADR, please approach me, Dave Jennings, here at Churchill Tax Advisors, or my colleague Imad Ilyas at Churchill Tax Advisors. Give us a call, contact our office, has the direct number, 0207 998 1834. If you've got our numbers, give us a call on the mobiles or drop us an email. Let's see if we've got any questions. Also, the recording of this will be available to everybody who's missed it today. Thank you for everyone who's attended. If you have attended, you'll get an email link to this recording. If you've registered, you will also get a link to this email, this recording, and it will be available on YouTube as well, as are some past recordings. So let's see if we've got any questions. There's one here. I guess we've sort of covered this point anyway. Are you obliged to go straight to the tribunal, or can you use one of the other options?
So, like you said, there is echo. Can you hear me clearly, Dave?
Yes, I can hear you clearly now. Yes, thank you.
All right. Yes, like you said, we have covered this point, but it's not really an obligation. The answer to that is you have the other options that we've covered, so you don't have to directly go to tribunal. You might have to, just as a procedure for the purpose of ADR, you might have to put a tribunal appeal, register it with the tribunal, but then that can be put on hold and you can revert to the ADR process. But like I've said, you should consider all of the different factors that we've mentioned today before going to tribunal. So and this is what we say to most of our clients: just look at the cost element. It's not just the cost; it's just how long do you want this to go on. Most people will want it to be done as soon as possible, and they opt for ADR. So the answer to that question is no. You're not obligated to go directly to tribunal. You should try and exhaust the other options which are available to you.
Yes, no, thank you, Imad. Another question is saying which is the most expensive route to go down as far as professional costs and fees are concerned.
Without a doubt.
Yeah, tribunal is definitely the most expensive route. But you know, with other cases, you don't. You know, it depends on what work is involved. You know, with the ADR, you've potentially got obviously a fixed fee situation there, because you know how much time is going to be spent at the ADR. You know how long you're going to need the preparation for. So that can usually be done on a fixed fee basis, and it's going to be a lot less than going to the tribunal.
Yes. What we'd say is obviously applies generally from what we have seen, i.e. ADR, a tribunal can be the most expensive option. But if you have a very, very strong case where we know we have weighed the risks and we know how much time it will take, then tribunal can equally be a good option. But again, generally speaking, tribunal will be the most costly option.
Yeah. No, good. I think we need to wrap up now. Obviously, if anyone's got any other questions or needs advice, or you've got appeals, you've got inquiries, got investigations, then please do contact us. I'll let Imad conclude if he's got any other points, but otherwise, thank you very much for joining us today. Do join us in 2 weeks' time for a tax planning webinar, and Imad and myself will be back in a month's time for the next tax investigations session. Thank you.
Thank you. Yes, Dave, I think you've comprehensively covered everything. I have nothing to add, and just thank everyone for joining, and we look forward to seeing you next month then.
Cheers. Goodbye. Have a good day, everyone. Thank you. Bye-bye.
Thanks. Bye.